Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. As we had previously notified you, the Idaho4 Defamation case, styled as Rebecca Scofield versus Ashley Guillard, filed back on December 21st, 2022, and proceeding in federal court for more than 3 years, is scheduled for a 4-day jury trial commencing Tuesday, the 24th of February, 2026. There has been some last minute on the courthouse steps activity going on in this case. The plaintiffs filed a request for the court to take judicial notice of certain matters. It is document number 125. It was filed by Plaintiff Scofield February 18th, 2026. And what it says is plaintiff, by and through her attorneys of record, requests the court take judicial notice of the following documents: the indictment charging Brian Kohberger with crimes, including the unalivings of 4 University of Idaho students, and marked in this case as plaintiff's exhibit number 22. And then there's also a supporting declaration of plaintiff's counsel, Wendy J. Olson, in further support thereof. Then if you go to page 2, the plea agreement in the case dated June 30th, 2025, in which Brian Kohberger agreed to plead guilty to crimes including the unalivings of 4 University of Idaho students, and marked in this case as plaintiff's exhibit 23, further supported, ladies and gentlemen, by plaintiff's counsel's declaration marked as exhibit B. And then the judgment of conviction and commitment dated July 23rd, 2025, in which the Honorable Stephen J. Hippler adjudged Brian Kohberger guilty of crimes including the unalivings of the 4 University of Idaho students, and sentenced them, I believe this should be him, and sentenced him for these crimes, and marked in this case is plaintiff's exhibit 24, and then further supported by plaintiff's declaration exhibit C. Then she goes on and states, Federal Rule of Evidence 201B as in boy provides that a court may judicially notice a fact that is not subject to reasonable dispute because it, 1, is generally known within the trial court's territorial jurisdiction, or 2, can be accurately and readily determined from sources whose accuracy cannot reasonably be questioned. Under Rule 201C, a court must take judicial notice when so requested by a party and the court is provided with the necessary information. The court may take judicial notice at any point in this proceeding. Fed Rule Civ Pro 201D is cited here. Then plaintiff goes on. Here, Professor Scofield requests that the court take judicial notice of the readily ascertainable facts that 1, Brian Kohberger was charged with the unalivings of 4 University of Idaho students that occurred on or about November 13th, 2022. Number 2, Brian Kohberger pleaded guilty to the unalivings of these students. And number 3, Brian Kohberger was adjudged guilty of the unalivings and sentenced for these crimes. And so what it appears plaintiff is doing here is asking the court, because this is a case for defamation where count 1 alleged that the defendant defamed plaintiff by stating that she was culpable for these crimes, that she in fact ordered them. The judge has now ordered that the defense respond to these items. So we're going to continue to monitor the docket for when defendant files her response, followed by the reply from plaintiff. And then we'll also note that the 23rd, Monday, the day before trial, there's a final pretrial conference. B, any possibility this case is going to settle before jury trial on the 24th. Until next time, this is Kathy. Thank you for joining us here today.